Welcome back to London, everyone. I'm pleased to say that we're out and about in London today. On the other side of the river there, you can see one of London's iconic landmarks, the London Eye, the observation wheel. But I'm not actually here to talk about that. I'm here to talk about the criminal justice system as it works today, because I'm standing right outside the headquarters of the Metropolitan Police here in London. Their headquarters is known as New Scotland Yard, and we can see the famous revolving sign here. So what happens? Let's start at the beginning. You are suspected of committing a criminal offence, and so the police can arrest you if they have reasonable grounds to suspect a criminal offence. And you'll be taken to a police station and you'll be given your rights, and that includes the right to speak to a solicitor, an attorney, a lawyer. And that's where I come in, because although I wear this thing telling you I'm a blue badge tourist guide, my background is in the law. I practiced criminal defence law for 20 years, so this is my bread and butter. I'll get a phone call, please come down to the police station, there's someone under arrest who needs your assistance. When I arrive at the police station, I will get from the police as much information as I possibly can achieve to find out why they are there. And then my job is to advise my client as to whether to give an interview. You might think to yourself, well, why would they want to speak to the police? Surely they have the right to remain silent. Well, they do in your system. Here, it's slightly different. Just as in your system they are given the Miranda warning, here we call it the caution. And it goes like this. You do not have to say anything, but it may harm your defence if you do not mention, when questioned, something you later rely on in court. Anything you do say may be given in evidence. That's quite a mouthful, isn't it? Can you imagine trying to understand that when you're locked up in a police cell? So my job is to explain it. So it's in three parts really. The first part and the third part is the same as your Miranda warning. You don't have to say anything, and if you do say anything, it can be used against you. But listen to that middle part again. It may harm your defence if you do not mention, when questioned, something you later rely on in court. If you're charged with an offence and you've said nothing in the police station, you go to court, you give evidence at court, the jury might decide they're not going to believe you. Why should I believe what you're saying now? Because you didn't say when you had the chance to say it in the police station. So it's quite a fundamental difference between our systems. After the interview, we might have said something, we might not have done. The police will then look at all the evidence, including what we said in the interview, and make a decision as to whether they think they have enough evidence to charge with a criminal offence. And then they will go to lawyers, what you call the district attorney. We call it the Crown Prosecution Service. The lawyers of the Crown Prosecution Service will look at all the evidence, make the decision as to whether you should be charged with a criminal offence, and then the police will charge. You will then appear before the magistrate's court, and that's where we're going to head to next. So I'm now standing in front of the City of London Magistrates Court. And there are magistrates courts all over London, whether it's shoplifting, criminal damage, drink driving, all the way up to rape, robbery, terrorism, murder. Every single case starts in the magistrates court for its first hearing. So once you're charged, this is where you come. But you might walk in the door because you're on bail, or you might be coming from downstairs, the cells. Because very often the police, once they've charged you, they will refuse you bail, put you before the court, and it is for the magistrate's court to make the initial decision as to whether someone is to be released on bail. Now, bail here is very different to the United States. As I understand it, in the United States, it very often involves a bond, paying a sum of money. Completely different here. Here, it's entirely based on legal argument, laid out in the Bail Act of 1976. And what the court is looking at is this. You have a right to bail. If you're charged, don't forget you're innocent until you're proven guilty. And so you have every right to walk out of that police station and show up at the magistrate's court of your own volition. You call it on your own recognizance. But the court will look at objections to bail. So the Crown Prosecution Service will present to the court reasons why they think this person should be refused bail. And what they're looking at in particular is three things. Is there a risk that this person, if released from court, will not attend court? Secondly, is there a risk that, if released from court, they'll commit further offences? Thirdly, is there a risk that if they're released from court, they will obstruct justice or interfere with witnesses? Now, it might be that the court will decide, well, we do have some concerns, but there are conditions that they can place on your bail which will answer those objections. So I'm going to give you just an example. Let's say you're someone who's never been in trouble before. You've got a good job right here in the financial sector, but you have been accused of hitting your wife in the domestic setting. So is there a risk you're going to fail to attend court? Well, there's no reason to believe that. There is no background in not attending court, and so there's no reason to believe that person will fail to attend court. But what might they do if they walk out of the police station or walk out of the court? Well, what they might do, potentially, is commit a further offence. They might go back to the matrimonial home and hit her a second time. Or what they might do is go back to the matrimonial home and say, darling, I love you, it won't happen again. In other words, try to persuade her to not go to court as a witness. And without that witness, you have no case. So obstruct justice, interfere with witnesses. So there are concerns, but these could be answered by, for example, saying you can go and live with your brother in a different city. And that will then at least allow you to carry on going to work, for example. So bail applications is something that is heard in the magistrates' court. Some cases are dealt with straight away. They're sentenced immediately. And those would be the lower level offences, what you call misdemeanours, and we call them summary only offences. Things like drink driving. Some offences are so serious, they only have one hearing here and then they immediately go up to the Crown Court, the higher court, to be dealt with, and we call them indictable only. So that would be terrorism, murder, rape, grievous bodily harm. And then we have a succession of cases which are kind of halfway between the two. And we call them either way offences. They are cases which could be tried here, but you have the right to elect trial by jury. And the best example of that is theft. Theft is an offence of dishonesty, and so it is an either way offence. Now if you think of an offence like theft of a sandwich, theft of a sandwich value £1.99 from Marks and Spencer. Doesn't sound like a very serious offence, sounds like a misdemeanour. But in fact, it's either way. You have the right, if you wish, to elect trial by jury. So when you come to London, you'll have the opportunity to come in and watch proceedings in the magistrates' court. And then what we'll do on another occasion is go and visit the Crown Court, where those more serious cases take place in front of a jury. So I'm now going to head us over to the Old Bailey Central Criminal Court to tell you more about that. Look all the way to the top of this building and you can see the figure of justice holding the sword and the scales on top of the dome of a building which is popularly known as the Old Crown Court, where the most serious criminal cases are heard. You'll remember we talked about triable either way and also indictable only offences. So sometimes you can elect trial by jury, sometimes you have to have trial by jury because the case is very serious. And this is a Crown Court where you would be tried by a jury of 12 people. And of course you have the same system in your own country. Trial by jury. Came from here, went to the United States. Jury selection is a little bit different over here compared to in your system. In your system, the lawyers get lots of opportunity to be able to strike people out of juries for whatever reason they like. It's a little bit more tightly controlled here. Normally, the way you would strike someone from a jury would be done by the judge. And it might be, for example, that you've got a holiday booked, and you book that holiday before you were called for jury service. Or, let's say you've got a hospital appointment. And another way you might be excused from a case is because you've got a personal connection. So it might be theft from a supermarket in Manchester, and you work for that same brand of supermarket in Birmingham. You don't know anything about the case, but you work for an employer who's involved in the proceedings. So of course you're too closely connected to the case. Now, because these are the most serious cases, potentially you can be given the highest sentence that is possible to be given in this country. Life imprisonment without parole. That's very rarely done. In fact, we call it a full life term. Normally, for example, murder, you'll be given life imprisonment, and then they would state a minimum term that you will serve before you can then apply. But of course, the biggest difference between our system and your system is in many of your states, you have the death penalty. We do not have the death penalty. And we have not had the death penalty since 1964. Actually, where I'm sitting used to be an execution site. Because if you go back to the 19th century, we had public executions. Kind of gruesome, really, to kind of think that I'm sitting here in a place where people were hung. And people would come and watch the public executions. People would be given a day off work, they'd bring their picnic hampers, oh, let's go down and watch the hanging. We had public executions until 1868. The London Underground, our subway system, opened in 1863. So for 5 years you could go to a public execution on the London Underground. That gives you a bit of a flavour for how recently it is. Now from 1868, the executions were done inside the prison until we finally abolished the death penalty in the 1960s, as I say. When you come to London, you'll see so many more of these comparisons. We will talk about things that we do the same, and we'll talk about things that we do differently. We don't have the right to bear arms, for example. Sentencing for carrying a knife is extremely serious, which of course is not the case in the United States. So I really hope you're going to be joining us in London very soon.